What is franchising? What are the components of franchising law and agreement? We are going to talk about it in this video. Stay tuned. The franchise agreement is an agreement between a franchisor and a franchisee. That agreement will entitle the franchisee to use the brand name, services and products of the franchisor. It goes into great detail on what the franchisor anticipates of you as a franchisee in terms of how you run every aspect of the business. There is no standard form of franchise agreement since the terms, conditions, and operational procedures of various franchises differ greatly depending on the type of business.
A franchise agreement secures each party, it protects both the franchisor's brand and the franchisee. You will be making a big financial commitment when you purchase a franchise, and you have rights that can help protect your investment in your company when an agreement is made. The rights and responsibilities of the parties are stated in the franchise agreement. There is no employer-employee connection in a franchise. According to the franchise system, as the franchisee, you run a different firm. The franchise agreement reflects the fact that you are an independent business owner. As a franchisee, you have a wide range of special rights, such as disclosure obligations. The franchisor is required to give you a copy of your franchise agreement and the code of conduct along with an information statement highlighting some of the main advantages and hazards of franchise arrangements. Additionally, the franchisor is required to give you a disclosure document that includes details such as operating costs and fees. These expenses could include the franchisee's initial and recurring fees, marketing expenses, fit-out expenses, and lease-related auxiliary expenses. Whether you have an exclusive territory. An exclusive territory is a site where you have the exclusive right to carry out the obligations of the franchise, in competition with all other franchisees within the network. End-of-term arrangements. In this initial disclosure document, franchisors are expected to describe the rights that franchisees will hold at the conclusion of the initial term. Franchisees and franchisors are legally required to act in good faith. In order to fulfill the terms of the franchise agreement, parties are required to collaborate and act in good faith in all of their interactions with one another. This responsibility covers every facet of the franchising relationship.
The term being described on franchise agreement refers to the time of period in which a franchisee may operate the franchise. Typically, the time period can be the date before the expiry date or most franchise legal years of up to 5 years. Most businesses only provide 5 years of term period given for franchise to operate the business as stated in the franchise agreement contract. From a legal perspective, the term period where a franchisee can use the franchising system that includes 1. Use the intellectual property including trademarks, brand, etc. 2. Access the operation manuals, training, support systems, assistance, etc. Understanding legal requirements is crucial when launching a franchise network. The franchise disclosure document and the franchise agreement are two legally essential documents that you should become quite familiar with before franchising your firm. The franchise agreement must be signed by each franchisee, as well as by the franchisor. As a franchisee, you might want to have one reviewed on your behalf by a franchise lawyer before signing. The franchise disclosure document is a legal document that a franchisor in the United States must provide to potential franchisees. It provides important details on the franchisor. The 23 sections of information in the disclosure must be presented in a precise order. The official franchise disclosure document is sent by the franchisor to a potential franchisee. Before potential franchisees pay money or sign a legally binding franchise agreement, the franchisor is required to give them the disclosure at least 14 days in advance. This ends our discussion. I hope you learned something from us. Thank you.